Hi everybody, it's Andy and welcome to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over how to modify a child support order in California. So this video is not going to be specific to dads or specific to moms, specific to parents who pay or parents who receive. This process in general is going to be universal, I suppose. So if you are, no matter which category I guess you fall into, this video should hopefully apply to you. So a while ago I put out a video that goes over how child support in California is approximately computed. I say approximately mainly because I did not go over every single factor that goes into child support in that video. There are a lot of them that I did not go over mainly because they are kind of more rare, or the effect on the overall child support amount is fairly small. So the two biggest factors, the two most kind of influential factors rather, is basically going to be, number one, the gross monthly income of each parent, and number two, the percentage of time that the child or children in question spend with mom versus dad. So all of that said, then, if you are in a situation where you are paying child support, you might logically wonder, okay, well, when the child support order was established, my kids were 8 years old, 9 years old, something like that. If I have to keep paying child support until they're 18, what do I do over the course of 9 or 10 years if either of these two factors changes? So the answer to that question, sort of in the abstract, is to basically that you should get your child support order modified to reflect what the current state of these two factors is. So if that is your situation, like you need to modify your child support order mainly because, for example, you've changed jobs, you earn less than you did before, etc. There are a couple guiding principles, guiding rules that you need to remember. The first one basically is that the child support order is not, like the current order I guess, is not automatically modified when reality changes. So you need to basically follow your court order, the current court order, until it is modified by the judge. And that modification process is something that you have to generally initiate. This oftentimes is a problem for people, I'll pick on dads again. If a dad is paying child support, this is often a problem if the dad goes to prison or is otherwise incarcerated. So let's say, for example, that dad gets arrested for a case, or let's say he gets arrested for a parole violation or a probation violation, etc., and then all of a sudden is sent back to prison. If that's the case, a lot of times, people in that situation, I guess, will assume that because they owe child support to the state and they are now in a state prison, for example, the prison and the child support people will talk to one another and the child support order will automatically be modified down. In general, that is not the case. The modification needs to be initiated by the dad in question. Understandably, that's not going to be easy if he's in prison, but it is something that the dad needs to do. It is not automatically done. People who are in that situation and they assume, incorrectly of course, that it is automatically done, a lot of times will come out of prison and be shocked at the amount of child support that accrued while they were in prison. So basically the bottom line is go ahead and follow your court order until it is modified, but if circumstances change, go ahead and get it modified promptly. So the second kind of guiding principle, second guiding rule, is basically that if you are going to get your child support order modified, any court order actually, not just specifically child support, if you are going to get any court order in California modified, you have to have something called a change in circumstance. Think of a change in circumstance like this. A court order, I guess depending on how you want to visualize it, it's either at the top of a pyramid with a lot of stuff beneath it supporting it, stuff meaning like facts, evidence, etc. Or it could be like you have a bunch of facts and evidence kind of lined up in a line, and then the conclusion is basically the court order. Like all of this stuff over here logically means this is the court order. If any of this stuff or this stuff changes, the court order that results from it is, possibly no longer applicable, doesn't really make sense. That is what change in circumstance basically means. So the underlying circumstances have to have changed. Kind of going back to the child support example from earlier, if child support is largely dependent on these two factors, gross monthly income of each parent and the percentage of time that the child or children spend with each parent, If either of these changes, then that qualifies as a change in circumstance that may result in your court order being modified, your child support order rather being modified. So yeah, so I guess those two are the guiding rules. Number one, follow your court order until it's modified. Number two, if you are going to pursue a modification, make sure you have a change in circumstance to support it. A lot of times people who are trying to modify court orders generally, child support or other orders, a lot of times they will not have a change in circumstance. If you're in the situation and you don't have a change in circumstance, the odds of you getting a modification are pretty small. There's a lot of case law, a lot of statutes, law generally, I guess, in California that says that if you don't have a change in circumstance, trying to modify an order might be viewed as a collateral attack on an issue that has already been resolved. Don't worry if you don't know what that means, but basically, if you don't have a change in circumstance, you will generally lose your attempt at modification. So all of that said then, the background, the guiding rules, all that stuff, how do you actually go and do a modification? So there are two processes. One of them is fairly well known, but the second one isn't. So I'll go over the well-known one first, and that one, as you can probably guess, is the kind of generic advice to go hire a lawyer to do the modification for you. In general, hiring a lawyer is probably going to be a little bit faster, and it's going to be more personalized, I guess. You'll interact with your lawyer more so, and you'll have somebody to kind of handhold, I guess, for lack of a better word, your hand through the process of modification. The downside, of course, is that finding a lawyer is expensive. You may not be able to afford it, etc. So there are a lot of benefits to hiring a lawyer, but practically speaking, it is not for everybody. That's why the second option here is pretty important. And the second option for modification that perhaps not a lot of people know about is have the Department of Child Support do it for you. So DCSS is the acronym for the Department of Child Support Services. If you are in the child support system at all, that's an acronym that you are pretty familiar with. One thing that, well, actually, let me back up. If you are in the child support system as a person, as the parent who pays child support, you probably know that the child support people, DCSS, can garnish your wages, haul you back into court, etc. Not a lot of parents who pay child support know that DCSS can also do modifications. It is not something that they perhaps advertise a whole lot, but it is something that they put it online, like they put the process online, they have forms for it, you fill out, you submit, etc. So the good part, I guess, the upside of having DCSS do your modification for you, the big one, I guess, is that it's free. The DCSS does not charge you for it. The downside is that it is kind of a drawn-out process, I guess. As you can imagine, DCSS has a lot of cases and relatively few resources in terms of people, courtrooms, etc. So if you want to pursue modification, you might be waiting a while, longer than if you hired your own lawyer. But of course, the benefit is that DCSS will do your modification for free. So to kind of cement this point, to really drive it home, in the description below, I'm going to put some links to DCSS websites in various counties in California. I'm going to go for the big counties, and I'm going to specifically link to pages where they have modification instructions. Each county's process is unfortunately a bit different, but the overall kind of idea, the takeaway from this video, is that the process can be done through DCSS, although it is not necessarily kind of straightforward, I guess. You might have to make a whole bunch of phone calls, you might have to wait a while and stuff, but it can be done. So hopefully all of that made sense. The takeaway from this video basically is that you have to fulfill certain criteria before you can get your child support order modified. Modification is a good thing because factors that child support depends upon can change. You can hire a lawyer to do the modification for you, or the lesser known kind of option is basically have the Department of Child Support Services, DCSS in your county, do the modification for you. You might have to wait a little bit, but the DCSS modification route is probably more available to people. So hopefully all of that made sense. Go ahead and share, like, comment, subscribe, all that nice stuff. And I will talk to you guys next time. Thanks.